can a person hand over their pack of cigarettes to a friend after they've been arrested? All right, my name is Anthony Bandiero, attorney and senior legal instructor, bringing you the Roadside Chat. So this question comes from an officer in Arizona. He said, I was recently on patrol in a hotel parking lot. I noticed a few people congregated around a car. I ran the registered owner of the car. She hit with a felony drug warrant and a misdemeanor shoplifting warrant. I pulled up a driver's license photo of the female and saw that she was one of the people standing around the car. I walked up to the group. I walk up to her. He called her out. Hey, whatever her name is, let's say Lisa. Hey, Lisa. She responded to the name. Okay, boom, we got her, right? Just going to confirm that. He asked her to sit on the curb while the warrants are being confirmed. The warrants were confirmed, and I asked her, advised that she was under arrest. At this point, she pulls out a pack of cigarettes from her pocket and handed it to her boyfriend. Now, what can we do here, right? Can we get that pack of cigarettes back, or are we kind of done? I would say get the pack of cigarettes back. All right. So this is a good question. Okay, this is a very good question. So we have a case called Robinson, where the Supreme Court upheld the search of a pack of cigarettes as a matter of routine based on search incident to arrest. We also have a case called Gant that applied to vehicles, but courts seem inclined to apply it to containers, where the court said if the person cannot access the item, while they're being searched. I'm sorry, Gant said if the arrestee cannot access the car while they're being arrested, then you cannot just search the car as incident to arrest. So, in Gant, the officers arrested Gant for no license, no warrant. He was outside the car. He was, placed in the back of the patrol car. The cops then go up there and, search Gant's car and find a weapon. And when asked, why they did it, they said, well, that's kind of our procedure. That's the way we're trained type analogy. But there was no probable cause for the car. And so forth. And the Supreme Court said, hey, look, if you can't access the car, then there is no search incident to arrest doctrine, because the search into arrest doctrine is there to keep you safe, right? That's why we do it. But if you're not going to, if the suspect can't even access the car because they're cuffed and stuffed in the back of the black and white, then where is the compelling need to keep you safe, right? Okay, so. And some courts have been applying that logic to, like, backpacks, for example. So the person will be detained. Their backpack will be taken off their body, put on the top of the patrol car. They are investigated. They are then placed under arrest. Click, click, moved away from the backpack. And now the cops will search the backpack as incident to arrest. And some courts, like the 4th and 10th Circuit, Nevada and so forth, saying, well, actually, there's no reason to search that backpack anymore, not under search incident to arrest, because they can't even access the backpack. And I got to tell you, I understand the logic. I do understand a search incident to arrest. Many cops are going to resolve that issue by simply saying, okay, fine, we'll just do an inventory, because we're not going to be able to take their backpack to the jail without knowing its contents. However, there is a conundrum when somebody is on scene willing and able to take their property. The boyfriend is willing to take the backpack. The boyfriend is willing to take the pack of cigarettes. Okay. We don't have crystal clear law on these issues from the U.S. Supreme Court, but let me just share with you what we are teaching here at Blue to Gold. If the item is intimately associated with them and on their person at the time of arrest, search it. They're not going to be able to give up that property, okay? The cigarette pack is a clear example of that. So they can't just start, hey, you're under arrest, and then start tossing all their items out of their pockets and giving it to their boyfriend. That's not going to work, okay? So tell them, no, that's not how this works. Give me back the pack of cigarettes. And you search it incident to arrest, because it was on their person at the time of arrest. I think that is clear law under Robinson. However, if it is a backpack that is off their person when they were arrested, and there's a person on scene willing and able to take that backpack from them, so does not have to go to jail with them, I think you have a different issue. I think at that point, the Gant logic applies, and where that's a dividing line at the time of arrest, was it on their person? I think that's the best way to do it, in some sense. Maybe that's not good enough either, because if you take off the bag, but the point is in this case, if the bag is not on their person, and there's somebody on scene, you don't have to call anybody that is associated with them that's willing and able to take the bag. I think that the best move is to let them take the bag, unless you have probable cause for the bag or reasonable suspicion. But if you don't have any reasonable suspicion or probable cause, let them take the bag. Documented on your report, documented on camera that they gave up their bag to somebody else. They are waiving a claim against you if somebody takes their stuff. That it's going to be a very hard argument for them to win a lawsuit. That their friend or their boyfriend stole their Rolex watch. That's okay. They can claim it, but it's going to be hard to win because they gave up their bag. But you take that person to jail, and then what are some of your options? How about asking the person that took their bag after the person has left for consent to search that item? You could probably do that. What about, well, the consent is probably the best thing, but if you have reasonable suspicion, you can, maybe do a dog sniff and so forth. But you could ask for consent. You could say things like, man, it's kind of weird that they didn't want to take their purse to jail with them. Don't you agree? It's kind of weird. Isn't that kind of weird? If there's something in there that that you're not supposed to have, you can get jammed up on that too, because you'd be in, possession of that item, and you certainly don't want to get, jammed up on a crime that you didn't commit or want to commit, right? So do you want us to search that bag now that we know that you did not put anything in it, just to make sure there's nothing illegal in there? Maybe they'll say yes, maybe they'll say no. Those are some options. But if you don't have anything like that and they just want to take the bag, I think you're kind of done. That would be my advice. That's not true in every state. I'm just saying that when it comes to like logic and reasonableness, that seems reasonable, that people can give items of their containers to other people if it was not on their person at the time of arrest. Okay, and what are you going to do with what about the homeless person with the shopping cart full of all their stuff, and they want to give that to their friend, right? I'm certain you're going to allow that. Oh, but Anthony, that's a shopping cart versus a purse. Okay. What about the homeless person with a really, just kind of a nasty duffel bag of their personal items? Are you going to give that up? Probably. So why? Because it doesn't make sense to bring it to jail. Let the people have their stuff where they're at and so forth. It's a conversation. Just think about it. I'm not saying this is black and white. You talk to your agency. What do they want to do here? I'm just throwing out some things to consider with this scenario. If you like what we're doing here, like, subscribe, share with your friends. And until next time, my friends, you stay safe.